How's it going, everybody? This is Anthony Miranda with the Firearms Policy Coalition. Today I want to bring to your attention an important brief filed by FPC in the case U.S. v. Gutierrez, currently before the Supreme Court of Idaho. In this case, Mr. Gutierrez was charged federally as a felon in possession of a firearm. This happened even though his felony conviction had been reduced to a misdemeanor nearly 2 decades prior by an Idaho state court. In the early 2000s, Mr. Gutierrez was convicted of burglary and sentenced to a rider. In October 2003, after performing perfectly on probation, the court reduced Mr. Gutierrez's felony burglary conviction to a misdemeanor theft conviction. In its charge reduction order, the court expressly declared that Mr. Gutierrez was not to be considered a convicted felon. But when he was found with a firearm nearly 20 years later, he was charged by the federal government for being a felon in possession of a firearm due to his burglary conviction that long ago had been reduced to a misdemeanor. This case is currently before the Supreme Court of Idaho, and the issue is whether Mr. Gutierrez may be prosecuted as a felon in possession of a firearm despite his conviction having been reduced to a misdemeanor. Now you may be thinking to yourself, wait, didn't you say this was before the Supreme Court of Idaho? How does a federal charge end up there? That's a good question. You see, Mr. Gutierrez was prosecuted in federal court and he appealed the conviction to the Ninth Circuit. On appeal, the Ninth Circuit recognized that whether he could be prosecuted for a violation of federal law turned on a question of interpretation of Idaho state law. The Ninth Circuit certified the following question to be determined by the Idaho Supreme Court. The question is whether an Idaho state court order reducing a defendant's judgment of conviction for a felony offense to a judgment of conviction for a different misdemeanor offense changes the operative conviction for the purposes of the statute which prohibits the restoration of firearms rights to those citizens convicted of specific felony offenses. The question raised by the Ninth Circuit comes as a result of the interplay between various Idaho laws and what effect they have on the state's constitution. Under the Idaho Constitution, Article 1, Section 11, it is unlawful for the legislator to prohibit individuals convicted of misdemeanors from keeping and bearing arms. In fact, the Idaho Constitution expressly guarantees the individual right to keep and bear arms to everyone who is not a convicted felon. Idaho Code Section 18-310 controls restoration of civil rights within the state. Under this section, a person convicted of any Idaho felony has his or her full rights of citizenship restored automatically, except when it comes to firearms rights. For firearms restoration, a person convicted of a specific felony, like robbery, must make an application to the Commission of Pardons and Parole to restore the right to ship, transport, possess, or receive a firearm after 5 years after completion of imprisonment, probation, or parole. Where this gets messy is that under Idaho Code Section 19-2604, there is a mechanism for amending a person's prior criminal judgments and convictions. A court under this section can turn a felony conviction of certain defendants like Mr. Gutierrez, who are subject to the retained jurisdiction of the court, into a misdemeanor. If a person's felony conviction is reduced to a misdemeanor under Idaho Code Section 19-2604, then the Idaho Constitution, in its language, prohibits the legislator from banning that person from possessing firearms. Remember, the state's constitution says it guarantees the individual right to keep and bear arms to everyone who is not a convicted felon. Therefore, interpreting the Idaho Code to prohibit firearms possession by individuals whose felonies have been reduced would cause this section to run contrary to the state's constitution. FPC filed a brief in support of Mr. Gutierrez to this end. FPC argued in the brief that the Idaho Constitution expressly guarantees the individual right to keep and bear arms to everyone who is not a convicted felon. And Mr. Gutierrez was expressly declared by the court not to be considered a convicted felon. As such, it would violate Mr. Gutierrez's constitutional right to keep and bear arms if he were prohibited from possessing a firearm when he was only convicted of a misdemeanor. This brief was co-authored by FPC's Director of Constitutional Studies, Joseph Greenlee, and is available for you to read at fpclegal.org. So if you agree that Mr. Gutierrez is being impermissibly prohibited from possessing firearms, head on over to joinfpc.org and join us in the fight against this 2A infringement and other similar infringements. Your donations go directly to helping our team file cases and briefs of this nature. Once again, this is Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.